This is Baylee Butler.
Sorry.
You're fine. I am actually no longer a senior staff attorney. I'm now a managing attorney of pro bono. So I'm not doing as much as I was before, but I have a long history of this and kind of made my career doing work around kinship and foster youth and just kind of system involved youth. So I am with Southeastern Ohio Legal Services. We serve 30 counties across Appalachia and Southeast Ohio and Central Ohio. So all of my information, I'm licensed in Ohio. So all of my information is based in Ohio. So if you're not in Ohio, some of this information might not be as applicable, but hopefully you can take some nuggets away and at least know that you can ask an attorney for assistance. So I got started doing this work when I got a grant called the Youth Law Project, where I was actually based in a foster care licensing agency. And I saw a lot of youth that were returning, a lot of foster parents that were having traumatized kiddos and just kiddos who'd been through a lot, also helping some bio parents kind of re-engage. So I kind of got my start there and started digging into this world. And then through another grant called the Appalachian Children Victims Assistance and Prevention Program, we started focusing on the kinship side of it. How are the laws impacting kinship caregivers? Where are there gaps in the law? And then how are we supporting the youth that are it was actually focused on the opioid and drug epidemics, and kind of that led to a lot of kiddos being placed in foster care and removed from their bio families and often placed with kinship caregivers. So we were focusing on the legal needs of those families. I also currently serve on Region 10 of the Ohio Kinship and Adoption Navigator Programs Advisory Board. So I do a lot of training of kinship navigators in that region and trying to make sure that we're providing services and making sure that there are legal connections for kinship caregivers across Southeast Ohio where there are limited resources. So that's just a little bit about me. The agenda for today is we're going to talk about the good news and the bad news of succession planning. Hopefully more good news than bad news. Some things for you to think about as you're considering succession planning, some types of custody arrangements and determining custody and guardianship and kind of how those play into your succession plan based on what your legal relationship is to the child. And then also basic estate planning. I will kind of stop and just say that I do talk very fast. So if I need to repeat anything, feel free to pop it in the chat. Angela can always interrupt me, let me know that we need to go over something again. I'm happy to do that for you, or save questions to the end and I kind of clarify something if something doesn't make any sense. But I will make sure that you have these slides. I'll send them to Angela so that she has them, and then you guys can have it. I try to make sure that all of the information is on the slides, so it is some reading on here that I'll be doing, but it's mostly so that you guys have that resource after I'm done that you can go back and reference. Then of course you'll have the recording as well. So without further ado, we'll go ahead and just kind of jump in. So the good news and the not so good news. So the good news is there absolutely are ways that you can designate a successor or somebody who will come after you to care for the children that are in your care, either through guardianship or custody. The not so good news is that the probate court, juvenile court, or sometimes even children's services will end up with the final say, and they may not approve of the person that you designate. So it's important for you to really think through who your successor is and who you're looking to appoint. There are various different ways to do it based on your legal relationship with the child in your care and based on who the individual is. And we'll go through all of those and ways to designate successor caretaker next. But just know there are ways to do it, but there are some caveats in that just because that's who you want doesn't mean that's going to be the person who ends up with the children at the very end, because ultimately the court is going to have the final say. So the ways you designate your successor caretaker or who's going to care for the children after you are no longer able to care for them yourself really depends on how you are related to the child or how you are legally related to the child, meaning what is your legal relationship? Have you adopted the child? Do you have custody of the child? Do you have guardianship over the child? Or is this just an informal kinship caregiver position where the parents kind of dropped off the child and you just had this child and haven't had any bumps in the road and haven't really gone through the formal mechanisms to make sure that you have the court documents in place to care for the child? Everything's gonna be a little different based on just the differences. So if you've adopted the child, you're the parent and you can execute a will, you can designate who you wish to take care of your children in that will, or arrange for custody or guardianship in advance if you find yourself in declining health. The caregiver is the parent. They're going to be the ones who are able to arrange for everything and kind of make sure that everything is buttoned up. You have the same rights as any other, as the bio parent would have if something were to happen to them. So the good thing is adoption is kind of like the top tier as far as what your rights are. If you have custody through the court and you find yourself in declining health, you can petition the court and cooperate with the caregiver that you wish to turn over custody to while your health is still good, and in a situation where you are able to, you can cooperate with that caregiver to petition the court to designate the other person as a custodian based on your change of circumstances. You've had a diagnosis or you found that you are in a situation where you are in declining health. You can then take proactive steps to transition that child into another caregiver's care by participating in the custody process with your successor caregiver. If you have guardianship, you can petition the court to designate someone else as the guardian. You can certainly recommend who you'd like that to be. It'll ultimately be up to the court. And if you have not adopted the children, do not have legal custodianship or guardianship, then you're not really going to be able to designate someone to take over for the child upon your passing or your inability to care for the child, because you don't have any legal rights to that child as it stands. So you would need to go and make sure that you have legal rights to the child and then switch those over. But what might be in the best option if you are in an informal caregiver situation is to think through who that next person is going to be and encourage them to go through the formal process so that they have those legal rights. And then you participate as much as you're able to with all the information that you have regarding the child and the child's circumstances.
We do have a quick question. What is the
Yeah.
difference between custody and guardianship?
So yes, so there are two different things. So custody is generally through the common pleas court or the domestic relations court. It is you are the custodian of the child until that child reaches the age of 18. So the idea is that custody is meant to be a permanent placement for the child. It's meant to be a permanent situation. Guardianship is usually more of a temporary situation, unless it is for somebody who is disabled, or there can be longer term guardianships. But generally speaking, the court is constantly going back and reviewing that. So a guardian has fiduciary duties, meaning that they have to make sure that they are caring for the child and making sure that they are keeping, if there are like assets or financial pieces attached to the guardianship, that they are keeping things for the care of that child, and they're constantly doing audits from the court. So you have to go back like almost every year if you're a guardian to verify that everything's been done correctly. A custody is just saying, here's where the court is saying, here's who has legal and physical custody of this child. And it's the same sort of rights. You are the same, but it's different in the court's perspective. So the custody is from the common pleas or domestic relations court, sometimes the juvenile court. Guardianship is from the probate court. It is meant for people who have passed away or are incapacitated and unable to care for themselves. So it is a different court. It's a different court process, a different part of the law.
Cool. Thank
you. Mm-hmm. So things to think about when you're selecting a successor caretaker, if you're thinking about this and you want to kind of think about who is the best person for this, you want to think of someone who shares your values. Someone who's going to be, if you are a religious person and takes the child to church, someone who's also part of that faith and who's going to kind of maintain and understand your wishes and have similar values to you in raising the child and similar beliefs. Someone who is financially capable of caring for the child. In addition, they might receive other sources of support, like they might be receiving Social Security, or if the parents passed away, some death benefits. Just various, they might be receiving disability on their own, or VA benefits from a parent if the parent was a veteran. So there might be some finances that come with the child whenever they are moved into somebody else's custody. But you want to think through, in addition to those, who is able to give that child the life that you would have given them, or that you want them to have. So think through that. You want to consider the character of the person you designate, because the court may not ultimately approve such the person. The court is going to look at the designated person's criminal history. They're going to look at their former drug use or current drug use. They're going to be drug tested, background checked. There's going to be a lot that happens. So making sure that somebody is able to, if you're putting them up for those things, making sure that they're able to pass those tests for the court. You might also want to consider someone who's young enough to take on the responsibility until the child reaches adulthood. All the studies show that moving children around and not providing them that stability is difficult and hard for the child and hard for them to, in their development. So thinking through, how can we minimize the number of times this child is going to have to change custody arrangements or change hands, and what is going to disrupt their life the least. If the biological parent retains visitation, which often happens in custody situations, then you want to make sure that the person you are designating is willing to continue to foster that relationship, because that's what the court is going to look at. If they're not willing to, or they're not able to, or they fail to, then the court, even if the court does designate them to be the next caretaker, the court could revoke that. So you want to make sure that you're thinking ahead and thinking through somebody who's going to actually fulfill the court's wishes and the court's orders. If you are leaving money and assets to care for the child, it's important for you to know that you can designate somebody else other than the guardian of the child to manage those assets. You can do a guardian of the estate versus a guardian of the person through various different means. And if the person who you want to care for the child is not responsible enough, or isn't the person who you want to be managing the money, then there are ways for you to kind of set that up. So if you have a guardianship with a child, then your designated successor will need to go back to the probate court and seek to be the successor guardian. If the biological parent retains any rights, and because their rights have not been severed, then they will have the right to come into court to contest the change, and even to contest the guardianship as is. So it's kind of like reopening the can of worms, and gives the bio parents another bite at the apple to say, hey, they're not able to care for the child. I am now. Look at me and look at all the things that I've done that has changed for me. It kind of reopens that conversation. Your wishes will certainly be considered by the court, but they are not binding on the court, meaning the court is going to have the ultimate decision. They will hold a hearing. They'll determine whether the successor guardian is a suitable person after they've done a background check, and they will have to have done fingerprinting, background checking, and they will also have to attend a class every year regarding their duties as a guardian and as a fiduciary of the child's care. And just like the person who is the guardian, the successor guardian has to make a written report yearly of the child, how the child's been doing, the child's outcomes, and if there's anything the court is looking at as far as the child's health or the child, the finances of the child, if the parents if there was something left for the child that needed to be managed as far as the finances go, there will be an accounting of that as well. If you have custody through the court, so that would be through juvenile court, common pleas, domestic relations court, then the designated successor will have to go back to the same court that you went to get custody to seek a modification of custody. If the biological parents have not had their parental rights severed, which is often the case in custody situations, then they will have the right to come to court and object to the modification, to seek custody themselves, or speak to visitation arrangements. So their wishes will also be heard, because that is part of the best interest test for the child. The court will listen to the evidence and make a determination as to the best interest of the child. And your designation of a custodian will be an important factor, but once again, it's not going to be binding on the court. So it's important to kind of have somebody prepared and understand kind of why this person would be the next best person to care for the child.
I have a quick question on this one. So for the successor, it doesn't take your custody away at that time. It's like after you pass away, the next person would get custody, or you're unable to care for the child.
No, so you are asking the court, say you're returning custody over to them. And what it could look like, and what I often see whenever we are thinking of successors, when people who have declining health or are unable to care for the child because the child's getting older and they're just unable to physically, deal with the child's needs, mental health wise, behavioral wise, what have you. What will happen is the person will go in and they'll say, okay, we're going to start transitioning to this caregiver. So, I'm in a situation where I'm not able to care for them, but we're going to do this kind of step down tiered approach where it's like, okay, you're going to start having like weekly visits with this new caregiver. You're going to have overnights, once a month with this caregiver, and start like kind of stair stepping down to them being ultimately the caregiver. But it is in a situation where it's like once you're gone, this is what happens. this is for you, in order for you to have the most say, it is best to be proactive and do it ahead of time, because once you're gone, it is then up to the person who is who you want to be the caregiver to petition the court and to speak on behalf of the court on behalf of your wishes. And you can put it in the will, which we'll talk about that in a little bit. But ultimately, the only way to have your voice actively heard in court is to be proactive and to be physically present in courts to have those conversations and to give testimony as to why the person you're turning custody over to is a better fit and is a better person for the best interest of the child.
That makes
Does that
sense.
answer? Yeah.
Yeah, and then, sorry, one more. So there is a chance if the birth parent has a chance to go to court here then and kind of fight for their rights when you
Right.
do this. Okay.
Yep. Anytime you go back to court, it opens it all back up, and the court has to reevaluate the best interest of the child and the change of circumstances. Now, ordinarily for custody, a bio parent couldn't just come into court and say, hey, I want to petition a change of custody. I mean, they can, and the court will hear it, but the court's not going to give it any real credence or credit, because there has to be a change in circumstances in the life of the current caregiver. What this situation is, because it's succession planning and because something has changed in the caregiver circumstances, you've already admitted that. You already said there has been a change of circumstances. So then it opens everything back up, and it allows for the caregiver to, or the bio parents to say, hey, consider me too, consider me as somebody. And the court will take into consideration the whole history, right? They're going to look back at the case and they're going to say, were you cooperative during this whole time? Did you follow my orders last time I gave you orders? Have you been visiting the child? You know, are you in the same school district as the current caregiver? And are you going to make sure that, those relationships the child has and that in the current caregiver's home are maintained? And it's a high bar for bio parents who've already been in front of a court and have already lost their rights. It's a high bar for them to jump over to say, I've made all these changes in my life, and look, I'm such a great parent now. Give me a second chance. It's not impossible, but it's a high bar.
Thank you. That was perfect.
Yeah. Okay. So, kinship placement through children's services. So, we know birth families are ultimately the place where children are supposed to be raised. And then if they're unable to be and children's service gets involved, they remove the child, they place in kinship. Caregiver, if that doesn't work out, or there isn't a caregiver willing to step up, they go to foster care. If they have higher needs or there isn't a foster family available in their county, then they might go to group or congregate care. Well, if the child's been placed in your care as a kinship caregiver as part of that situation with children's services, and there's been an open case against the bio parents, they're going for an abuse, neglect, dependency, and it is an open case. Not that, I've had many families say, like, that's how I got my child, or that's how I got my grandchild or my niece or my nephew. If that case is closed, you've already gotten permanent custody through children's services, or you've already gotten custody through children's services, and that case is closed, the abuse, neglect, dependency is no longer going on, then this is null and void. But if it is open at the time, whenever either you pass or you're in a situation where you're unable to care for the child, then the situation is that you have only ever had physical custody of the child, because whenever the case is ongoing, the state or children's services has legal custody of the child. So if you're no longer able to care for that child, then children's services makes the ultimate determination of where that child should be placed, either in another kinship caregiver home or in foster care or in a group or congregate setting, depending on where they are on that ladder. So you can definitely make suggestions on who you would prefer the next caretaker be. If there are other kinship people that you're aware of that are willing to care for the child, you can certainly mention that to them, and they have an obligation to explore that option and to look for other kinship placements. And if you're giving them one right then and there and saying, hey, here's who it is, it's my other daughter, or it is, my sister who's willing, they've already told me they're willing to take care of this child. Children's Services has an obligation to look into that, to research it, to do all the same background checking that to make sure that would be a safe placement for the child. But ultimately, it is up to Children's Services. There is always the option of your preferred successor, if they've been denied or Children's Services isn't moving fast enough because they have to go through the background checking process, or then that they then remove the child out of your care because you're unable to care for them and put them into foster care, which nobody ever wants to see. Then the the successor person that you're asking, your sister, your other daughter, whoever, can separately petition the court for consideration as a kinship placement. The court has to consider that request, but ultimately the court realistically listens to Children's Services and will defer to what Children's Services is. So it is a step that can be taken. It at least puts it on the court's radar and says, hey, I've tried to get somebody else involved here, which is great, because then the court can oversee that and can make sure that they hold Children's Services' feet to the fire as far as their obligations. But ultimately, they defer to what Children's Services believes is best, because Children's Services might know something about that person's history or their background that you were not aware of. Another way that I see that kinship caregivers often have physical custody of the child is through a grandparent power of attorney or a caretaker affidavit. A grandparent power of attorney is a power given by the biological parents. The biological parent signs off and says that, I'm going to give power of attorney to a grandparent of this child. And it has to be a grandparent. It can't be anybody else in the other relation. So if the grandparent is no longer able to provide the care, then the biological parent will be asked to determine if there is another grandparent that can take responsibility, if they're unable to take the children back into their biological parent's care. So ultimately, it's up to the bio parents to re-sign a grandparent power of attorney, but it has to go to another grandparent. It can't be anybody else. Very similarly with caretaker affidavit, the difference between a grandparent power of attorney and a caretaker affidavit is, in a caretaker affidavit, the grandparent is unable to locate the bio parent. So that's in a situation where the child has just been kind of dropped off and you haven't seen your child in forever, or, whoever it is, your grandchild's parent, you haven't seen them in a while, and you don't know where they are, you can't get a hold of them, they're not answering their phone, they don't want to talk to you. I see that a lot happen. Then a caretaker affidavit can be filed saying, hey, I am the grandparent of this child. I have tried to locate the parent through X, Y, and Z process, haven't been able to do so, but I need to be able to get this child enrolled in school, or I need to be able to get this child seen by a medical professional, or I just need legal rights to this child. Then that's what a caretaker affidavit does. So grandparent power of attorney is where the bio parent says, yep, sounds good to me, you can have them, and signs it off to the grandparent. They can always revoke it, but they sign it. A caretaker affidavit is saying, hey, I'm the grandparent, I don't know where the bio parent is, help me, court. But in a situation where the caretaker affidavit is in effect and you're no longer able to care for the child, the grandparent's no longer able to care for the child, then only another grandparent can file another caretaker affidavit saying that I would like to take care of the child now, and you can revoke your caretaker affidavit by signing it off to the court and saying I'm no longer able to care for this child. If there are no grandparents available to take on the care of the person, to take on the care of the child, then the person who's willing to care for the child has to go through court to obtain custody or guardianship. They cannot go through the easy process of a caretaker affidavit or a grandparent power of attorney, because those are only available to grandparents. Okay, so preparing for succession. So once you've determined that there is someone that should take over the responsibility if you're unable to provide the care, then it's important for you to plan with that person. Make sure that you communicate with them, make sure that they're willing to take care of the children upon your passing, or, if you're already in declining health, they're willing to take over now, and determine if they're willing to accept that responsibility. You should make sure that you have access and that they have access, or at least copies of all the legal documents that you have in your possession, so that they can take the appropriate action. So if you have custody, if you have guardianship paperwork, you should make sure that you have all of that in a binder, everything that's happened through the case. If there's been, I've seen some custody cases go on for years because the bio parents keep dragging it on, or want to bring it up every time, or file contempt of court for every little thing or everything. You want to make sure all of that is in a binder and you're keeping it kind of all in one space. And then you're letting the successor caretaker, or the next person that you're asking to care for the child, make sure they know where that binder is. Make sure that you've gone through it with them, that they understand, like, here's the process, here's how I got this child, right? Like, either there was drug involvement or abuse, neglect, dependency, or they just dropped the child off. Had the parent been coming to visits, they need to kind of know what the situation is and what that relationship is, because they need to be prepared. If you're not willing to turn over the custody now, because you're in fine health, but you just want to make sure that you're planning ahead, they need to make sure that they have all the information. So I always recommend people, try to keep a journal, keep a calendar, of visits, keep a separate calendar and then mark on it, visit scheduled for, such and such time at McDonald's, parent no showed. And then just make sure that they have access to that. It's all part of the binder. So you're keeping those notes and keeping them up to date so that if the next person comes in or something were to happen to you, they know, okay, I go to this binder and this is where it's all going to be. And it's really easy for me to just go to court and say, hey, here's all the information. I know what's happened. I have this whole history and I have, evidence from the previous caregiver from you stating what everything was going on with those visits. So there isn't really a relationship with a bio parent as they're trying to tell the court there is, or they haven't been supporting the child as they have been, as they're claiming, because you're not going to be there to make those statements in court. If the biological parent still retains rights to the child, and if they're not willing to agree to the modification of guardianship or custody, you want to make sure that your designated person has all of that relevant information. If they have a criminal history, you want to make sure that criminal history is there, that you're printing out new ones as they're coming out, so that that's all part of the binder as well. Providing that your designated person with the information about the history is just going to be helpful for them and context for them, and gives them more ammo whenever they go to court to say, hey, their bio parent is saying all these things, but look at all this evidence, court. Look at all the stuff that I have because, you prepared it for them. And it helps the court kind of understand that you would be in the best interest and why the bio parent is not in the best interest of the child. If you're in declining health, like I mentioned earlier, you may consider petitioning the court early and kind of stair-stepping that child to the next caregiver. It provides them more stability. It provides them more time to kind of acclimate to the situation. It allows you to help them through the transition to the next caregiver, and allows you to be able to be available to give testimony in court as to your actual experiences with the child, the wishes of the child, and your experience dealing with the bio parent, whether they've been involved or not. It's a lot heavier weight of evidence for the court to consider whenever you're there in court telling them, versus somebody else coming in and saying, yeah, I've got this binder and I have this calendar that they created, but there's no one there to actually verify it. So while it's still evidence, it's just not as heavy of an evidence for a court to weigh. So it's important to kind of, like I mentioned earlier, be proactive when you can.
We do have one quick question.
Yeah.
With grandparent power of attorney, do both biological parents need to sign off?
No, it's the custodial parent. So in Ohio, unwed mothers have full custody of their child until the father takes them to court and gets any kind of legal custody or legal rights to the child. So if that's the case, then you only need the mother's signature. But no, you generally only need one. But if they're married and together, then it's best to have two.
That was it. Thank you.
Yeah. Great. Okay. For some reason, I have this on here twice, but so you're going to see this slide twice, which I don't know why, and it looks different each time. But anyway, so we're going to do some basic estate planning. I always like to talk to people just about basic estate planning documents, because you hear these things and you're just like, oh, do I need these? What are they? I also have a nice link here, which, like I said, I will provide you the PowerPoint so that you have it. But what the link does is it is a kind of workbook. Like it's like 5 pages, and it allows you to kind of write everything up for your executor or whoever's going to take over for your estate to say where everything is. So it can tell you can write in there like where the custody papers are, and or what is in there. You can write kind of if you have somewhere you want to be buried, all that information is kind of in a workbook, and it's just for you to kind of turn over. It says, yep, I've got a will. Yes, I've got a living will. Yes, I've got a healthcare power of attorney. Yes, all my organs donated, or no, I want to be cremated, whatever it looks like. It's just kind of like a workbook that is to help somebody go through what happens after somebody's passing, because that is a very emotional time. Often an executor is somebody who is close to the person, which a death can be very, very difficult. So it kind of gives them the step-by-step process of kind of like what happens when somebody passes. What do I do? Where do I go to get the information? And it allows you to kind of put all that in one place. So that is what the link is. So just in general, estate planning documents, a will is where you tell the world kind of what your last will and testament is, where you want all of your belongings to go. Now, people often ask me, oh, I have one child. Do I need a will? Well, yeah, you might need a will. A will will, so if you die without a will, there is a law, there is laws in process to say where your belongings go. So I have people who's like, oh, I've only got one child and I'm separated, okay, well, your spouse still has dower rights, meaning they still have the right to come in and take from your estate, unless you write them out of your will. They're going to have some rights still, but you can minimize it in a will. If you have multiple children and you don't want one of your children to inherit, it's important to have that in the will. Otherwise, the statute says that your children take equally after your spouse. So there are various reasons why you might want a will. Now, a will has to go through the probate process, which is an entire opening an estate, and it's a whole court process where the court gets involved and distributes assets. They have to get involved if 3 things are involved in your estate. So if you have a bank account, if you have property, and if you have a vehicle. Now, Ohio kind of fixed the vehicle one by saying that a spouse can get one car, I believe, but it can't be a truck. So if you have a truck, then it has to go, it's a whole thing about how they define what the vehicle is, or a camper. But if you have more than one vehicle, then that has to go through the probate process. You can bypass that, however, by putting transfer on death affidavits or payable on death affidavits. So you can talk to your bank and say, hey, bank, I know who I want to be able to access my bank account. It's either your executor or your spouse or whoever. Even if they're not on the bank account, you can talk to them and say, put a payable on death beneficiary on my account just by talking to the bank. And you'll sign a piece of paper, go in, and it allows that person to bring in your death certificate. And then they have access to your account without having to wait for a court order. Similarly, you can do that on the title to your vehicle. You can put a transfer on death beneficiary on the title to your vehicle. You do have to pay for a new title for each vehicle, but it says where each vehicle goes. I recommend that if you buy a new car, that you consider that whenever you get your first title, then you don't have to pay for the second one, right? Because you don't have to redo it. But if you have a vehicle and you want to make sure it goes somewhere without having to go through the probate process and without waiting for a court order, then you can put that on your title to your vehicle. Then all the person has to do is bring in the death certificates to the BMV, and the BMV will issue it, and they'll pay for a new title to that person that you have designated as your beneficiary. Same as with land. If you have property, a house, land, wherever, you can put a transfer on death beneficiary on your deed. It is actually a separate document from your deed that gets recorded in the county recorder's office. And it says, upon my death, this property is going to be transferred to whomever you list. You have to pay for the recording fee, which is different in each county. And you can revoke it at any time. The person has no rights to the property until you pass away. If you sell the property, then nothing, no harm, no foul. They don't have any rights to any of the proceeds for that sale or anything like that. It only becomes valid upon your death. And then they bring in the death certificate to the recorder. Actually, they bring it to an attorney, get a new deed drafted, or a new affidavit drafted saying I now own this property, and then they pay the recording fee. And that property then goes to them without waiting for the court order, without having to go through the probate process. So that's what the transfer on death and payable on death pieces are.
Real quick, can you repeat that last part about the property? Hi, I'm sorry.
Hi.
You said it too fast and I was trying to write it down. About the property and recording it with somebody. Like I have property and I want to leave my property in the event that I die. I want to leave my house to my grandkids.
Yep. So what we do is you would execute a transfer on death affidavit. And you can do that by talking to an attorney. Legal aid can help, depending on which county you're in. Pro seniors might be able to help. Those are different entities in Ohio that can kind of help with these types of things. But what you would do is you would just record the transfer on death with the county recorder of the county where the property is in. And then upon the death, then all that would happen is your grandchildren have to go to an attorney. They would then do an affidavit of survivorship saying, grandma passed away. We are the beneficiaries of the property. Here's her death certificate. Then the attorney would draft up, a new affidavit saying, here's the property, the legal property description. They would take that to the county recorder, pay the recording fee, and the property would be transferred to them.
Okay.
Without having to go through court, probate, without going through that whole process.
Okay, I feel like that's something that sounds like a lot to do, and I feel like I need to start now for the
Yeah.
future. Thank
Yep.
you so much.
I always recommend that, and it's an easy way to kind of avoid the probate process.
Okay, thank you so much.
Yeah. So the other pieces that I usually recommend to people that they haven't thought about and don't have already is a healthcare power of attorney and a living will. Actually, let me back up a little bit. So talked about the will, and now there's also trusts. There are various types of trusts, and I will caveat and say I am not an estate attorney. I do basic things for low-income individuals, so a lot of my clients don't have a lot of assets to kind of worry about in a trust. A will and a trust can do a lot of the same things. You can have both documents because they act differently depending on the court. What the trust does is the trust puts all of your assets into essentially I liken it to like a corporation. It's not a corporation, but I put it as like, okay, now my estate is a business. It's not. That's not how Ohio looks at it, but it's separate and apart from you as the person. So it's taxed differently. Whereas the will is like your personal estate. It kind of like just is a way that rich people found to work their way around a lot of the tax laws. So I don't do a lot of trusts. I don't do any trusts. So I don't know a ton about trusts. What trusts do, though, is a lot of people will come and say, I want my grandchild to be able to have X number of dollars out of my estate when they turn 21, or only for the purposes of going to college, or only if they get married, or whatever it is. That cannot be done through a will. A will only passes, it can pass money, but it just says, upon my death, my grandson gets $5,000. It can't say, upon my death, my grandson gets $5,000 only if he turns 18 and decides to go to a 4-year college. A trust can do that. So that is a separate document. You really need to talk to a specialized estate planning attorney for that. There are also special needs trusts. So if you have someone in your care who has special needs and you want to make sure that you are putting stuff away for their care, but they're not going to be able to manage the asset themselves, or maybe the money isn't going to go to them, but it's going to go to the facility where they are being cared for, that is usually done through a trust as well. The trusts do different things than wills, but kind of act similarly. So I want to make sure I add it here because a lot of people ask a lot of questions about it. I can't answer a lot of questions about it, but I just want you to know that it is an option, is something you can talk to an attorney about. So living wills, what living wills are, is it is a document that allows you to decide whether or not you want to be sustained on life support. If 2 or more doctors agree that you are in a permanently vegetative state and you are not going to wake up, or you are not going to have brain function if you were to wake up. So that allows you to decide whether or not you want to remain on life support and living off of machines. It is a hard decision for family members to make. Often family members don't know the right thing to do. A lot of family members feel a lot of guilt having to make the decision and wondering if it was the right thing to do. So this allows you to say, look, I am however many years old, let me go. I've had a lot of clients say, like, I don't ever want to be on life support. This does not mean that you will never be on life support. It doesn't mean they're not going to try to help you and bring you back. What it means is that if 2 doctors agree that you are in a permanently vegetative state, so they've agreed that we've already put you on life support, we've already given you the breathing treatments, we've already done CPR, we've already done everything. But now we know, because you've been in this state for so long, and 2 doctors have consulted and said, look, based on the brain function, all the testing we've done, your loved one is gone. Then it allows your living will to kick in and say, okay, she has living will, and she decided that if the situation happened, she doesn't want to live on life support anymore. So doctors don't even consult the family. They have the living will, and they say, okay, we're going to call the people who are in the living will to be by their side, and we're going to remove the life support because that's what this person wanted. That's different from a DNR, or a do not resuscitate order. A living will is a legal document that doctors have to follow. A do not resuscitate order is a document that you sign at the hospital that removes liability from the hospital for not providing life-saving care. So that's usually for people who are in terminal situations where they do not want to have somebody giving them CPR or using the defibrillator machines on them. They're just like, look, I know I'm dying as it is. Please don't put my body through more trauma. Just let me go if it's my time to go. That's what a DNR is, and it is signed at the hospital. It is a separate document, and it is only good at that hospital. Whereas a living will is good wherever, and you should make sure that your doctors have it. In any hospital, if you were to call 911 around you and where you would be taken would have it on file. It is a legal document that everyone has to follow. So those are two different documents. A healthcare power of attorney is kind of a step down, and it is in a situation where you are in a situation where you are unable to care for yourself. So it might be like I liken it's like a car accident, or maybe you've gone into like a routine surgery and they put you under anesthesia, and you're gonna wake up. Like they expect you to come back. They expect you to make it through the surgery, but something has changed, right? They're going in to do some kind of exploratory surgery, or they're going in for something routine, and they go in and they're like, oh, maybe the cancer has spread or something has changed that they didn't expect, and they need to make a decision right then and there. They can't wake you up because they've got you open on the table. So who do they ask? The healthcare power of attorney says this is the order of people that you ask. You ask my spouse, then you ask my child, and then whoever you want them to ask. But they make the healthcare decisions for you. It also allows you to sign off and say, give all of my medical records to that person to make the best decisions. It waives HIPAA so that the doctor doesn't have to worry about breaking HIPAA, because they can talk to that person about your medical needs and your medical care. Once you're able to make healthcare decisions for yourself, you're awake and you're able to do that, you take all of that back. They no longer have that option to make that decision for you, or any decisions for you. You make them for yourselves. What the healthcare power of attorney also does is it allows you to designate who you would like to have as a guardian in the event that you become incapacitated, such that you are unable to care for yourself or your finances. So if you have dementia, or something that would happen that would be declining health such that you are unable to care for yourself for one reason or another, then the healthcare power of attorney says, okay, courts usually don't know who to ask. And they will ask your spouse, and then they'll ask your oldest child, and then your next oldest child, and then your sister. Like they have an order they usually go in. But I've had clients say, my oldest child lives in Seattle and they're not going to be able to care for me. Like, don't ask them. They're going to put me in a home somewhere where my youngest child, lives with me and will care for me anyway. So it kind of tells the court, the order that you want them to ask for guardianship. It does not put the burden on the person. It does not mean that you are saddling your youngest child with you for the rest of their lives. It just tells the court, ask them first. So then they can say, I can't care for her right now. I've got other things going on, or, I'm not able to take that on right now for one reason or another. They can decline it with the court, but at least tells the court what order you want them to ask. So that is the healthcare power of attorney allows you to do a lot of different things to manage your healthcare in the event that you are unable to manage it yourself until you're able to manage it yourself. Then we have financial or durable power of attorney. They're the same things. Those allow somebody to manage your finances as if they were you. So while I tell everybody, I think everybody should have a will, I think everybody should have a healthcare power of attorney, I think everybody should have a living will, absolutely. I think everyone should think before they do a financial power of attorney or a durable power of attorney, because that allows somebody to act as you, even while you are acting as you. So they can go to the bank and they can write checks for you. You can write checks for you. They can go to the bank and take money out. You can go to the bank and take money out. They can open a business in your name. They can buy and sell your house. They can do everything in your name that you give them the right to do. And it's great for older individuals who are, having difficulty dealing and managing all those things. And you have to sign it while you're competent. But it is dangerous because you are giving somebody a lot of power over your entire life. It is severed upon death. So upon death, they cannot just go and drain the bank account. Once the minute you pass away, that power of attorney goes away, because then everything gets turned over to your executor, or then your next of kin as far as the estate planning goes, your will, or your trust, or however you die without a will, then by the statute. But it is a very powerful tool. It gives somebody a lot of power over your finances and over you. Have seen it backfire on people, but it can be a peace of mind to make sure if for some reason you're missing, you're forgetting to make your mortgage payments, or you're forgetting things that, you wouldn't forget ordinarily. It does allow them to make those payments, to talk to the mortgager on your behalf, to make those negotiations if there is a foreclosure coming, things like that, so that it's taken off, the burden is taken off of you. Let's see. We talked about transfer on deaths for vehicles and property. We talked about dealing with probate, as far as when you go through probate is whenever there is anything that is titled. So a bank account is titled to you, a vehicle is titled to you, land is titled to you. Those go through probate. Everything else, the Elvis collective commemorative plate collection that you have, that doesn't have to go through probate unless family wants to fight over it. That usually those things don't go through probate. Your personal effects, your belongings, your clothing, the furniture, that stuff doesn't usually go through probate unless families start fighting over it and it's not clear in your will, or you don't have a will stating where those items go. I have seen personal property go through probate when there is no will and somebody has like a lot of antiques and they're like, oh, and family wants to fight over, well, so-and-so, we're supposed to get this equally because of what the statute says, but just because I got 4 pieces of furniture doesn't mean I got 4 pieces of furniture that was worth the same amount as, Jesse got. So then they'll want to fight over it. And then that brings the court in, a lot of court fees, a lot of hassle, a lot of just terrible stuff. So thinking through where all that goes. I do also want to kind of put a plug in really quick for Medicaid estate recovery. People who are on Medicaid who are over the age of 60, even if you don't realize it, sign a piece of paper. That's whenever you sign to get Medicaid every year, you are signing estate recovery, meaning that the state has the right to come in after your death and take from your estate the amount of money that they have paid for your care, for your health care from the time you were 60 on. So that can be a large amount, it can be a little amount, depending on if you're in a nursing home, though that's, what is it, like something like $7,000 a day now, or $8,000 a day now, something like that. So Medicaid pays a lot of money towards those things. So then because Ohio is the way Ohio is, they then get to come in and put a lien on the house, or take from the estate. They can't do that if you have a living spouse. They'll put a lien on the property, but they will allow the living spouse to live in it. Or if you have an adult disabled child, they will allow that adult disabled child to remain in the property. But if the house were to be sold, the lien for Medicaid would have to be satisfied. So I just want to make sure that a lot of people don't know that Medicaid estate recovery exists. They know they get Medicaid, they sign off to get it. They don't realize what it is, but it is for them to come in and to recover from your estate the amount that the state of Ohio has paid for your care as much as they can, which then prevents a lot of money and a lot of wealth being transferred to your children or through your will. All right, like I said, I have a second, I don't know why I have this secondly. I don't know why I did this twice, but I did. So that is all I have, because I wanted to leave some time for questions.
I do have a few in the chat to go through. Yeah, I saw you unmuted yourself too. I didn't know if you had something.
No, I'm fine. I didn't unmute myself. I'm
okay.
sorry.
That's okay. So we have a few really good questions. The person who asked about the power of attorney earlier, she followed up with the question. So if both biological parents have legal and physical custody, will both need to sign the power of attorney?
Yes.
Okay. Thank you. Kim said, can you get transfer upon death for 401k accounts and other retirement accounts?
So that's a great question. I should have added on here. No. And the reason for that is because retirement and pension accounts are separate contractual accounts, meaning that there are beneficiaries that you put on that account. So you should, if you need to change those, or you need to figure out who's on there, because whenever you fill out your documents for it originally, you do put on beneficiaries, but a lot of people forget, right? And they'll get divorced and they won't update because they never changed their work. They won't update it. So you want to make sure that you contact your pension, whoever holds your pension, or your 401k, your work, whoever, and find out who your beneficiaries are and put them on there, and make sure those are updated with updated contact information, and just update them periodically. If nothing's changed, then you're probably fine, but it's always good to know, because those pass separately. They do not go through your estate because they are a separate contract that you have made with a financial agency. If you create a trust, I know that you can make your trust or your trustee the beneficiary, which then means the money goes into the trust, and then the trustee can do things through it. Like I said, I'm not a guru on trusts, so I can't tell you all the ins and outs of that, but I do know that that's an option, and a lot of people do that. So if you go the route of doing a trust, a lot of times the attorney will talk to you about making sure that the money from your your life insurance policies and your 401ks, like all of those go through your pensions, that all of those go into your trust so that all the money is kind of consolidated in one place for tax purposes. But no, it is separate, and it is like a separate contract that has a beneficiary designated on it. And what will happen is once you pass away and the pension, the financial company is aware of your death, which they get notified through like your employer or your, they get notified separately necessarily than beneficiaries doing it. It might take a little bit more time, but they'll get notified usually through Social Security. And they will send the check directly to the beneficiary. So it's important to have the updated information updated. And the beneficiary might not even know they were a beneficiary. They'll just get a check in the mail. And other beneficiaries might not know that you had the account, right? Like if you have a spouse and you didn't want them to get it, so it went to your children, and your children and your spouse are estranged, the child doesn't have to tell anybody that they got that check. The spouse might not know, and the company won't be permitted to talk to them about it because it's private information.
Thank you. We do have one more question too. Are trusts always for estates of $100,000 and above?
No, they're not. People do them for various reasons. I've seen lower income people do them. Like I said, I don't do trusts. So I can't talk to you about the pros and cons about when to do them. If you talk to an estate planning attorney, they're going to tell you absolutely everyone needs a trust because they want you to pay them to do the trust. And it's going to cost a couple $1,000s to even do the trust. So I think it's, worth exploring and researching kind of when it's beneficial. I think that the reason that you see them for more people who have $100,000 or more into their estate is because of tax reasons. Because once you hit a different tax bracket, a higher tax bracket, you get higher death taxes. And people are trying to avoid those. So
is it also true that trusts can't be contested in court or like the probate court?
I don't know, and that I won't say that. I think they can be. I think they're just a lot harder. They're a lot more difficult to contest.
Okay. Thanks. We do have a few minutes left. Thank you. This was so much great information. I will tell everyone I'm recording this, so I'll be sending this out later this week or next week so you can rewatch it and go to the different parts you need to, because I know it was a lot of information, but really good information. So does anyone else have questions either